of your own free will? Now, ma'am, the state has indicated that pursuant to negotiations on your behalf with your attorney, that it's expected that you will enter a guilty plea as charged to count one, possession of a fentanyl-related compound of the fifth degree. In exchange, the state is asking the court to dismiss counts 2 and 3. Is that what you talked with Ms. Cox about before this hearing? Ma'am, did you have an opportunity to review this 3-page plea form before this hearing today with your attorney? And do you have any questions about it? Did Ms. Cox answer all of your questions about it? Do you understand what it says? Ms. Orr, do you believe you've had enough time to sufficiently consult with Ms. Cox about your entire case before this hearing today? And has your lawyer answered all of your questions to your satisfaction? Have you had an opportunity to either review and or discuss the evidence that the state has against you with Ms. Cox before today's hearing? All right. Mr. Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge, to the defense?
We have, Your Honor.
All right. Ms. Cox, do you acknowledge receipt of same?
Yes.
Ms. Orr, are you satisfied with your attorney, Ms. Allison Cox? Now, do you understand this charge in count 1 against you? Possession of a fentanyl-related compound, a felony of the 5th degree? Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in count 1 of the indictment? And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately? Now, count 1 being a felony of the 5th degree, do you understand that you're facing up to 12 months in prison and up to a maximum fine of $2,500? Do you understand that if I sentence you to prison upon your release from prison, you could be on post-release control for up to 2 years? And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand? Ma'am, are you on post-release control right now? All right. Well, do you understand that if you are on post-release control and you commit a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains on your post-release control time, or whichever is greater. Do you understand? All right. Do you have any questions? Well, I told you the worst case scenario, but since this is a felony of the 5th degree, community control or probation is a possibility. Do you understand that I could place you on probation or community control for up to 5 years instead of sending you to prison? Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court? And if I place you on community control and you violate the conditions of community control, then you would be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty could be the imposition of prison time up to the 12 months I previously discussed with you. Do you understand? Also, ma'am, if I impose court costs and you fail to pay those court costs, I could just order you to do community service instead of paying court costs. Do you understand that? Do you have any questions so far? Ms. Orr, when you plead guilty, you give up some very important constitutional rights, and I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, which is set for today, either to the court or to a jury of 12 persons? Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at a trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? And finally, do you understand that at a trial, you cannot be forced to testify against yourself? Do you understand each of these rights as I've explained them? Do you have any questions about your constitutional rights? Do you have any questions about anything we've discussed today? Do you understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights in this case? All right. Ms. Orr, knowing everything the court has discussed with you, do you still wish to enter a guilty plea as charged for count 1 of the indictment? All right. Counsel, anything further before I accept the plea?
No, Your Honor.
All right. May I hear a statement of facts?
Yes, Your Honor. On or about March 7, 2024, in Hamilton County, Ohio, the fentanyl obtained, possessed, or used a Schedule 1 controlled substance, to wit, acetyl fentanyl, in an amount less than 1 gram.
All right. Anything on those facts, counsel?
No, Your Honor.
Ms. Orr, did you hear what the prosecutor said you did?
Yes, ma'am.
Is it true? What is your plea to count 1, possession of a fentanyl-related compound, a felony of the 5th degree? Let the record reflect that Ms. Cody Orr was present in court with her attorney, Ms. Allison Cox, and that Ms. Orr was informed of all of her constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Ms. Orr understands the nature of the charge. Ms. Howell, can you put down the right date? Nature of the charge, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Ms. Cody Orr guilty as charged in count 1, possession of a fentanyl-related compound, a felony of the 5th degree, in violation of revised code 2925.11 subsection A. Counts 2 and 3 are dismissed at the state's request. Counsel, is there any reason why sentence shouldn't be entered today?
No, Your Honor.
All right. You waiving PSI?
I am.
All right. Any objection to that, state?
No, Your Honor.
All right. Would like to say on behalf of Ms. Orr.
Sure. So Judge Cody, as we heard from Mr. Remington, picked up this case in, I think, March 2024. Almost immediately after that, she went to transitions and completed 45 days of treatment at that point, which was inpatient, residential. It was somewhere that she could not leave at that point. She was discharged in July 9th of 2024, successfully completing the program, and next went to First Step. She went to First Step in July and was there July through October of 2024, continuing to do intensive outpatient treatment while also staying on their campus at that time as well. So she had left transitions, was doing IOP through First Step, but was living there as well. Since she completed First Step, she is now has switched over to the Crossroads Clinic. She works with the Crossroads Methadone Clinic on Burnett Avenue. That is something that she has been working on since March of 2024. She did have somebody with her, or somebody that wanted to come with her today in the last setting as well, but unfortunately they were not unavailable. She does have a counselor and works with somebody there as well. She's got a stable living situation. She lives at home with her husband. She's got 3 grown children. She's working right now at McDonald's. When I picked her up, she was working, I think, at Five Below, but has since switched to McDonald's and is actually in a training manager position at this point in time. So McDonald's, I think, is an employment. She has an employment history there. It's a place that she obviously felt comfortable going back to, and now they're considering her for a management position as well. Obviously, she is getting treatment. She is clean right now. We would ask her to consider putting her on some kind of probation that just permits her to continue with that treatment. She's done so well on her own. I'm not sure if she needs anything additional, but obviously maintaining that treatment and what she's been doing is something that she would be interested in.
All right. Thank you. State?
Your Honor, it does look like that she entered into the drug court program and spent about 6 months there trying to work the program. It ended up not being successful, but it sounds like she's making efforts outside of that context. We'd like to see those efforts continue. This is her first local offense, to my knowledge, the charges that arose out of this. She had some trouble, looks like, in Maryland, but outside of that, there's no reasons that just making sure that she stays on the street would not be the appropriate outcome.
All right, thank you very much. May I see counsel at sidebar for a moment?
I feel like maybe 2 minutes off now.
That's my case. And then I'm gonna look at the history. It says he was ordered for- No. CRD. Yeah, but that 20, that 3940, that is resolved.
Okay.
This is different.
I'm happy to get it recalled. I'm not on the case, I'm happy to sign on. What was the case number? 20169, is that the?
No, that's our case. It's this one. It's 20169. Yes.
What have you been special?
Can Your Honor recall the GPS?
Is it this time? Yes.
Okay. Right, I'm happy to go down there. and-
Take care of it.
Yeah,
Okay. All right.
all right.
All right, Ms. Orr, is there anything you'd like to say before I pass sentence? Okay. Has your treatment in at First Step and what was the other one? What was the other? Transitions. Did it help?
Yes, ma'am.
Okay. Well, I'm glad to know that it helped. You've done, obviously, substantial amount of work already to try to help yourself. Are you living on your own right now?
Me and my husband. Yes, ma'am.
Oh, you and your husband, and you finished all your treatment? All right, since you are working, I'm going to, just, order court costs. I'm not gonna put you on probation. I'm gonna do the 12 days Hamilton County Justice Center, credit for 12 days Hamilton County Justice Center, pay court costs. You have a right to appeal your conviction and sentence. Should you do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand?
Yes, ma'am.
All right, and so I wish you well.
Thank you, Your Honor.
Jones?
This is the matter of State of Ohio versus Jaden Jones. Mr. Jones is present in the courtroom with his attorney, Mr. Gary Goldman. Mr. John Rendering is present on behalf of the State of Ohio. This is case B2500957. Mr. Goldman, this is Mr. Jones's first appearance. His DSC is Friday. Can we take care of the DSC dates today?
Yes, Your Honor, I already set this date with Ms. Howard.
All right, excellent. What would you like to say on behalf of Mr. Jones with regard to the motion to reduce bond? Before I do that, Mr. Rendering, did you get a copy of the motion to reduce bond?
I did, Your Honor.
Okay, are you ready to proceed?
I am, Your Honor.
All right, Mr. Goldman, what would you like to say?
So first, Your Honor, a little procedural background on this. At his municipal court arraignment, bond in this case was originally set at $10,000, the 10% plus EMU.
Yes.
Mr. Jones called me the next day and said he lives in Franklin County, Ohio.
Mm-hmm.
That he had court appearances scheduled in Franklin County on March 12th, he was going to miss those appointments, those court hearings, if he wasn't released. So I went back to Judge Bouchard and met with his bailiff the next day. And first thing Mr. Bouchard did was check to see if there were any holders on Mr. Jones, and at that time there were not.
Mhm.
And he talked to the judge and the prosecutor and amended the bond. So on the EMU, Mr. Jones was allowed to live in Franklin County, so he could go up to Franklin County and take care of his Franklin County cases. Before Mr. Jones could post bond, the cash portion of the bond, Franklin County placed a hold.
Okay,
And further, EMU refused to put him on EMU because of the hold. And I confirmed that with EMU. And then I contacted Mr. Jones' attorney in Columbus regarding his Columbus charges. We spoke on, we didn't speak with by email on Friday. And he tells me the judge in Franklin County has now revoked his bond on those charges because he didn't make it to his hearings.
mhm,
So today, Mr. Jones' request, he's posted the cash portion of his bond in this case,
I see that.
but he's asking the EMU to be reviewed.
Okay. State?
Your Honor, as a preliminary matter, I was able to get in contact with the listed victim store, Lululemon. I reached out to the store and then was referred to their security person. Mr. Pennington indicated that they are actually in line or aligned with reducing bail, as this was not a violent incident. That was his choice of words. Your Honor, given that there is a warrant from out of county, I'm told that those are felony matters and actually seem to be more serious than the present matters. It seems that bond is appropriate, if not too low in this matter. And EMU would be a valuable tool to keep track of Mr. Jones. In that it sounds like if he leaves our jurisdiction, we may never see him again.
All right. Thank
Your Honor,
you.
Mr. Jones said he would like to address the question.
Did you speak with your lawyer first before did you tell him what you were going to say? Okay, go ahead.
Okay, so my name is Danny Jones. You know that already. I'm currently a student at Franklin University right now, and my girlfriend, she's 5 months pregnant. And before this incident happened, Your Honor, I was on house arrest on EMU for 10 months, and I had never missed a court date. I've never ran. And as soon as I got the information that I had a warrant for this case, I got a warrant for this case on the 25th of February. I turned myself in within less than 24 hours. I came down to this jail myself, and I turned myself in and told and let them know that I was here to turn myself in. And I had a warrant, Your Honor. I don't have no plans on running. I'm trying to get my life together. Everything's falling apart since I've been in here. I have to pay my own rent. My mom is sick. I have to take care of my grandma. Like, I can't do nothing from in here. And I don't know. And then it's just like, I don't even sit here and snitch on myself, but I know, like,
Well, before you snitch on yourself, make sure you talk to your lawyer, let him know what you're going to say. All right, I think I do understand the situation.
it's like, Your Honor, it's just like, Your Honor, I had courts in Columbus on March 6th. I got on March 7th is when the voter came. It's because I have a warrant in Columbus right now for misdemeanor charges right now. And I got a warrant on the 7th, Your Honor.
All right.
It's just,
So,
they won't. I paid my bond, I sit here and waited, and they won't lift my motor. I don't know what I have to do. I don't have no plans on running, Your Honor. I've never missed a court date. I just want to get my life together, take care. I have a family on the way. I'm going to get myself together. I'm going to start my family the right way. I'm going to get all this stuff out of the way.
mhm. Just breathe.
It's so hard. I sit with the jail phone and try to do my schoolwork. It's so hard for me to do my schoolwork through a jail phone.
I understand. I understand.
I had no plans of running. I don't even have nowhere to go.
Well, let me-
Myself.
I understand. I understand what you're saying, young man. I do. But your charges, it looks like in, Franklin County, if this is correct, I'm not quite sure, but these are not misdemeanor charges. These are
No.
serious.
I sat in jail for those charges and I paid a bond and I made it to every single court date on those charges.
I know, I understand, but I thought I heard earlier someone say those charges in Franklin County were misdemeanor charges.
No, I said I have a warrant for a misdemeanor right now at the moment in Franklin County. And
That's different than the charges you were going to court on.
Yes, ma'am.
I see.
And my lawyer said that they were supposed to be coming to pick me up, but my girlfriend, when that's pregnant, she called to my prosecutor in Franklin County, and they said they have no intentions on coming to pick me up.
Yeah,
And I paid my bond on March 9th, and this was the 24th, and they still haven't came to get me. I don't understand what's going on.
all right. So let's get these dates and then I'm gonna tell you what I'm gonna do. What are the dates, Ms. Howard?
Pre-trial on April 16th at 9.
April 16th?
Yes, ma'am.
And, oh, that's a pretrial, not a final pretrial.
Yes, ma'am, that's the pre-trial.
All right, and when's the final pretrial?
Final pre-trial on June 5th.
When?
June 5th,
June 5th.
at 9:30.
Mm-hmm.
And the jury trial on June 9th at 10 a.m.
All right. This is a felony of the 5th degree. I'm gonna, if I allow him out on EMU, we don't monitor EMU in Franklin County. So in essence, we would be requiring him to stay in a city that he doesn't even live in, without family and all of that, which doesn't make sense. So what I'm going to do is the bond has been posted. So the cash bond has been posted. I'm going to modify it to terminate the EMD. And, you know, hopefully he will get his bond taken care of in Franklin County and be back for the pretrial on April 16th. If you're not back on April 16th, and I will tell you that if he gets released, he can appear by Zoom on April 16th only for the pretrial, since he lives in Franklin County. He can appear by Zoom. I will consider that to be appearance, but then the rest of the dates, you have to be here physically. Do you understand? All right. All right, time waived.
Yes, Your Honor.
All right, anything else?
No, Your Honor.
Thank you very much. We'll vacate the DSC date on Friday. All right, Brenner.
Thank you, Ron.
You're welcome. Brenner's on his way down?
He's in the hallway.
Oh, he's on his, oh, okay, thank you. All right, this is the matter, State of Ohio versus Jacob Brenner, case number B2400761. Mr. Brenner is present in the courtroom with his attorney, Miss Allison Cox, and Miss Rebecca Barnett is present on behalf of the State of Ohio. This matter is on for hearing on several motions. I'd like to address today the motion to compel, motion for sanctions, and I want to discuss the proposed order for production of the victim's medical records. And then we'll see where we are. We possibly may get to the motion to dismiss, okay? But let's start with the motion to compel. Let's start with the discovery. Ms. Cox?
Yes, Your Honor. So Judge, specifically in this case, we do have a motion to compel pending. If I could just, my understanding was that you're just going to be talking about the order regarding the medical records, so.
Oh, okay. That's what you guys were prepared to do?
That's what Ms. Howard had indicated to me today.
Oh, do what?
That's what you get.
Mine just says hearing on motion. So that's why I thought it was for all of those. But I do need to know about discovery.
So, Your Honor, I filed for discovery on March 14th of 2024. Initially, the state provided a response on March 15th, which was obviously the very next day, providing my client's medical records. On the 5th of June, 2024, so about 2 weeks later, the state provided a laboratory report pertaining to evidence located.
About 3 months later. You said I think you said 2 weeks.
Oh, my mistake, I was reading May instead of March.
Yeah.
3 months later, we received a laboratory report regarding evidence located inside Mr. Brenner's vehicle. I've received the Bosch crash data retrieval information relating to the prosecuting witness's vehicle. But there are a couple of specific items that have not been produced. Specifically, all the body worn camera footage for all the officers.
Still?
Yes, Your Honor.
And it's over a year later.
Yes. Your Honor, I also don't have any of the motor vehicle recording footage or MVR footage from the officers that responded. I have a list of outstanding officers for which I am waiting on MVR. Same with BWC as well.
Which department agency is this? CPD? Colerain. Okay, do they even have that?
Judge, if I may, Ms. Cox and I have actually had a meeting at my office with the officer about this, to which he indicated to her that none of that stuff was saved.
It wasn't saved?
Correct. This is a case from late 2021 that was investigated. They had a very short retention period, and it was inadvertently never saved in that 30-day retention period. There's 2 body-worn cameras that were by chance saved that have been provided. That's all that exists, and they don't have NPR. Only doesn't have NPR.
So this was not saved back in 21.
Correct.
So even, he was indicted, what, in 22?
24. He was charged then in 2022. The warrant sat for about a year until he was located in early 2024, which is when the grand jury occurred.
That's the basis for the motion for pre-indictment delay.
Yeah, I know. All right, so everything in your motion to compel, and I take it, Ms. Barnett, you've seen this motion to compel.
Correct.
It does not exist. What about the lab report? The lab report, Ms. Cox is requesting the lab report substantiating the state's claims of Mr. Brenner's intoxication. Does that exist?
No, and this is something that Ms. Cox and I have also discussed outside of court.
This is an aggravated vehicular assault, possession of drugs, possession of cocaine, aggravated possession of drugs, operating a motor vehicle under the influence, and failing to maintain reasonable control. And there's no lab report for count 5, operating a motor vehicle under the influence?
No, Your Honor, I apologize. I didn't indict this case. This is a case that I got at the tail end of Mr. Krem's time in our office. This is why Ms. Cox and I have had several discussions regarding the evidence in this matter. And I apologize, this court date was changed and I had it on my calendar for tomorrow, so I don't have my file in front of me, but we are working outside the court to resolve this matter. And in
Okay.
spite of these discovery issues.
Okay. Okay. Is that accurate, Ms. Cox?
Yes, I had indicated this morning that we were trying to reach some sort of resolution that we had met. Wanted to see if Your Honor wanted to discuss some sort of open date, but
Given the posture of the case, I'm happy to entertain a resolution that the parties either agree on or don't agree on and want me to decide. I'm open. And it sounds like I may have caught you guys off guard, but I thought when this is a hearing on all outstanding motions, so let me address what you thought we were going to address, which is,
the order regarding the medical records.
okay,
Judge, I filed a motion after one of the last court hearings, a motion to get both the victim and the defendant's medical records. And I attached proposed orders, and Ms. Cox had indicated to me that she didn't object, but Ms. Howard said that you wanted to address the motion in court. So
yeah,
all the other motions, I guess, are in advance until that's resolved, so we can at least get those medical records.
okay. So there is an order by the state, which is a request also, and a proposed order to get the victim's medical records. All right. This copy that I have is actually file stamp copy.
I became aware of that after I had our admin file it. The proposed order was attached to it so that your owner will receive it, and it appears the clerk's office just filed.
They did, yes. Can you send a, Word
Yes.
document to Ms. Howard today?
Yes.
All right, and then I can sign it.
And I will say, Judge, that the medical records that the state is seeking to get is one of the items contained in my motion to compel Mr. Cartwright's medical records
Yes.
to see shape of physical harm.
I saw that. Okay, sure. Well, why don't you get me the entry, and I guess I could maybe, no, I want a clean one, okay? And then I'll sign this so you can get that, and so that would be granted. And then Wednesday, how close are you all to bringing this to resolution?
So it's my understanding, Judge, that the state still has to talk to the victim in the case. Obviously, we have met along with the detective at the state's office to discuss some of these issues at length. But everything obviously hinges on compliance with Marcy's law and input from the victim. So I think that's kind of where we're at.
All right.
There was an informal offer that I made, and this is a situation where I need to confer with the victim. I don't think that his position will change what the state does. I just haven't had an opportunity to have that conversation.
All right, when do you think you can have that conversation?
I can do that this week.
All right, well, this is the thing. I don't want to have a hearing on outstanding motions, particularly a motion to dismiss and motion to suppress, if you guys are going to be able to resolve it.
I understand that, Judge.
If you don't resolve it, then I'm going to hear these and make a decision. But if you can resolve it, then you don't need me for that, except to sanction the resolution, right? So I'm going to hold the motion to compel discovery, even though I think I understand the situation and the motion for sanctions, until I hear from you all on whether or not there's a resolution. And then you just let me know if we got a resolution or we don't have a resolution, and then we will set these matters for hearing. Now, I have a conflict with Wednesday at 1:30 to do a motion to suppress. So if you wouldn't mind, granting me some grace, I have a doctor's appointment and, I can reschedule that. Okay, all right, Ms. Howard, can you give us a date? We have a final pretrial April 10.
And I will say, Judge, I am out the week of the 31st to the 4th. So, next week.
Next week.
Yes.
We can do it all by April 9th.
Okay, any motions, hearings?
That's fine by me.
Is that okay? All right, so we'll do, what day is that?
It's a Wednesday.
Okay, so motions, hearing, all motions, hearings will be on April 9th. What time? You say 9, you say 10?
10 o'clock.
10 a.m. All right. I expect to hear whether or not there's a resolution before then. If there is a resolution before then I will resolve it on that day.
Great.
Okay? All right. Thank you very much. And I'll note that Mr. Brenner is present today.
Thank you, Your Honor.
Good morning, Your Honor.
Good morning, Mr. Malat. This is a matter of State of Ohio versus Eric Spiller, case number B2404846. Mr. Spiller is present in the courtroom with his attorney, Mr. Tom Malat. Mr. John Rendering is present on behalf of the State of Ohio. This matter is set for jury trial today, but looks like I've been handed plea documents and diversion paperwork. And, looks like Mr. Spiller has been accepted to the diversion program. That accurate, Mr. Malat?
It is, Your Honor.
All right. And the state, do you have an objection to that?
No, Your Honor, it's had to go through my office's process in order to get approval up to this point.
Okay, thank you. So, I'm going to, go ahead and take the plea and then process this for diversion, okay?
Your Honor.
All right. Are you the Eric Spiller named in this indictment? Mr. Spiller, how old are you? And how far did you go in school, Mr. Spiller?
I got my high school diploma.
So you're able to read and write the English language well?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Have you ever served in the military?
No, ma'am.
Mr. Spiller, I have in my hand a single-page document. It's entitled Waiver of Trial by Jury. And at the bottom, there are signatures. I recognize Mr. Malat's signature and his bar number here. Right above, though, is that where you signed your name, sir?
Yes, ma'am.
All right. This is an acknowledgement that you understand that you have a constitutional right to have a trial, which was set for today. But when you sign this form, you're indicating to the court, I understand that, but I don't want to have a trial. I waive or give up my right to have a trial. Is that your understanding of what you were doing when you signed this?
Yes, ma'am.
Did you have an opportunity to speak with your lawyer before signing this waiver form? Do you have any questions about it?
No.
Do you have any questions about your constitutional right to have a trial?
No.
I also have in my hand a 3-page document, and it's entitled Entry Withdrawing Plea of Not Guilty, Entering a Plea of Guilty. Up here it says diversion, so that's all. On the 3rd page, there are signatures. I recognize Mr. Rendering's signature here, he's the prosecutor. Mr. Malat's signature there, and then up here, is this your signature?
Yes, ma'am.
All right, thank you very much. Mr. Rendering, would you please put on the record the party's expectation regarding the plea?
Your Honor, I'm expecting to plead guilty as charged and enter and participate in the diversion program.
Mr. Malat, that accurate?
It is, Your Honor.
All right. Mr. Spiller, is that your understanding?
Yes, ma'am.
All right. Mr. Spiller, are you under the influence of any medications, any alcohol or drugs today?
No, ma'am.
Do you now, or have you ever had to manage any type of mental health difficulties?
No, ma'am.
Would you like to sit, Mr. Malat? Are you sure?
Thank you.
Okay.
Appreciate it.
Are you presently under any type of probation or community control supervision in this state or any other state?
EMU.
Okay, EMU, but what about probation?
Probation, no, ma'am.
All right. Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything at all if you enter into this plea of guilty today?
No, ma'am.
Are you making this plea of your own free will?
Yes, ma'am.
Now, the state has indicated that you're charged in a single count indictment with receiving stolen property, and that you're expected to enter a guilty plea as charged,
Yes.
and it's a felony of the 4th degree. Is that what you talked with Mr. Malat about before this hearing?
Yes, ma'am.
Did you have an opportunity, Mr. Spiller, to review this 3-page plea form with Mr. Malat before this hearing today?
Yes, ma'am.
All right. Do you understand what it says? Did he go over it with you?
Yes, ma'am.
All right. Do you understand what it says?
Yes, ma'am.
Did any questions about it?
No, ma'am.
Did Mr. Malat answer all of your questions about it?
Yes, ma'am.
Mr. Spiller, do you believe you've had enough time to sufficiently speak with your lawyer about your entire case before this hearing today?
Yes, ma'am.
And has your lawyer answered all of your questions to your satisfaction?
Yes, ma'am.
Have you had an opportunity to review and or discuss the evidence or the discovery that the state has against you? Have you done that with Mr. Malat before today?
Yes, ma'am.
All right. Mr. Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge, to the defense?
We have none.
Mr. Malat, you acknowledge receipt the same?
Yes, Your Honor.
Mr. Spiller, are you satisfied with your attorney, Mr. Tom Malat?
Yes, ma'am.
All right. Now, do you understand this charge against you, receiving stolen property?
Yes, ma'am.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the offense of receiving stolen property?
Yes, ma'am.
And do you understand that if you plead guilty, well, ordinarily I would say I'm going to enter a judgment of guilt, but because you've been accepted to the diversion program, I'm not going to enter a judgment of guilt. I'm going to hold it in abeyance. That means just hold it out there. And then I'm going to put you in the diversion program, and when you successfully complete it, and I hear from diversion that you are successful, then I'm going to dismiss the case.
Okay.
Do you understand?
Yes, ma'am.
All right. But if you're not successful, you don't do with diversion, the terms of diversion and your agreement, your promise, then I will accept your guilty plea and enter a judgment of guilt against you. Do you understand? And then we'll set it up for sentencing. Do you understand?
Yes, ma'am.
All right. Now, I need to go over a couple things with you. So, this is a felony of the 4th degree, this charge, receiving stolen property. Do you understand that you're actually facing up to 18 months in prison and up to a maximum fine of $5,000?
Yes, ma'am.
Do you understand that if I sentence you to prison upon your release from prison, you could be on post-release control for up to 2 years? Do you understand that?
Yes, ma'am.
Now, all of this would happen and come into play if you're not successful with the diversion, okay? And I'm gonna tell you right now. You understand that? All right. And if you are placed on, if you are sent to prison, you're released on post-release control. If you come out and you violate post-release control, then you could be sent back to the institution for a total of up to 1/2 of your original sentence. Do you understand?
Yes.
Are you on post-release control right now?
No, ma'am.
All right. Well, I'm going to tell you this, and then if it's probably not gonna ever come into play because you're gonna be successful in diversion. But if you're not, then I'm gonna tell you this again later. And that is, do you understand that if you are convicted of a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains on your post-release control time, or whichever is greater. Do you understand?
Yes,
All right. Also, this comes into play if you're not successful in diversion, and I'm fully expecting you to be successful. Since this is a felony of the 4th degree, community control is a possibility. Do you understand that I could place you on community control or probation for up to 5 years instead of sending you to prison? Do you understand?
yes,
And do you understand that if you are placed on a community control sentence, you would have to abide by all probationary conditions as established by this court? Do you understand?
yes, ma'am.
Also, if I place you on community control or probation and you violate the conditions, then you would be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty could be the imposition of prison time up to the 18 months I previously discussed with you. You understand?
Yes, ma'am.
Also, Mr. Spiller, if I impose court costs and you fail to pay those court costs, I could just order you to do community service instead of paying court costs. Do you understand?
Yes,
All right. You have any questions?
ma'am. The EMU, how much longer or?
Yeah, we'll talk about that at the end, but that's a good question. Any other questions?
No, that's
Okay. Well, don't let that question linger in your mind that is distracting you from hearing what I'm saying, okay? Because I know you want to get the EMU off. I know. When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, which was set for today, either to the court or to a jury of 12 persons?
Yes, ma'am.
Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes, ma'am.
Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify on your behalf?
Yes, ma'am.
Do you understand that at a trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
And finally, do you understand that at a trial, you cannot be forced to testify against yourself?
Yes,
Do you understand each of these rights as I explained them?
ma'am. Yes, ma'am.
Do you have any questions about your constitutional rights?
No, ma'am.
Do you have any questions about anything we've discussed today?
No, ma'am.
Knowing everything the court has discussed with you, Mr. Spiller, do you still wish to enter a guilty plea as charged to count 1, receiving stolen property, a felony of the 4th degree?
Yes,
All right. Counsel, is there anything further before I accept the plea?
No, Your Honor.
May I hear a statement of facts?
Your Honor, on or about October 5th, 2024, in Hamilton County, Ohio, the defendant did knowingly receive, retain, or dispose of a motor vehicle, the property of Linda Wisman, that's Wissman, knowing or having reasonable cause to believe that the property was obtained through the commission of a theft offense.
All right. Anything on those facts, counsel?
Nothing on the facts, Your Honor.
Mr. Spiller, did you hear what the prosecutor said you did?
Yes, ma'am.
Is it true?
Yes, ma'am.
What is your plea to count 1, receiving stolen property, a felony of the 4th degree?
Guilty.
All right. Let the record reflect that Mr. Eric Spiller was present in court with his attorney, Mr. Tom Allott, and that Mr. Spiller was informed of all his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Spiller understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea, but holds in abeyance any judgment on the plea of guilty. I have the diversion participation agreement already signed by Mr. Spiller, and your next appointment is April 24th at 9 a.m.
Yes, ma'am.
Okay. And I'm going to go ahead and execute these documents, and I believe there's no objection by the state. You have, I know you have your last question you wanted me to address, and I will address that in just a moment. Now, like I said before, Mr. Spiller, I'm fully expecting you to be, successful in this diversion. It's a wonderful, great opportunity for you to not have this on your record. But you have to dot your i's and cross your t's. Do you understand? Everything the probation or the diversion program personnel tells you, you have to do. Okay? All right. Now, I'll get to your question. Mr. Malott, you want to address the EMU?
I would ask that Mr. Spiller be taken off the EMU. And I realize that we're not in sentencing, but by way of mitigation, Mr. Spiller has continuously, through this process, been working. He's received his carpenter certificate through the union.
That's
He
great.
actually found a union job in Canton, Ohio. However, because of the EMU unit, he could not do that. This greatly frustrated Mr. Spiller, and we talked about it at some length, and I assured him that once we get to this point, the court would be inclined to take off this EMU unit. He can work and work in his chosen profession of carpenter.
Okay.
And I would ask the court to remove the EMU at this time.
All right. State?
No objection, Your Honor.
All right. Well, you recognize that your attorney can make no guarantees on what the court will do, right? Okay, he can just kind of tell you what I may do, what he hopes I'll do, what he expects I might do, but he doesn't know. You understand that? But in this case, he's actually right. So I'm gonna terminate your EMD, okay? Take off your electronic monitoring. Yes, yes.
Thank you,
So,
Your Honor.
you're welcome. All right, so, I hope not to see you back here.
You and I. Can I tell you something? I work with your great niece. I work for UTS. I work with your great niece.
Oh, who was that?
Ariana, UTS.
Oh, Ariana.
Yeah,
You-
I work with her.
How do you work with her?
In the morning, I'm the monitor. I be tracking her in.
He transports.
Oh, you're part of the transport team.
Yeah.
Oh, wow. Okay. So you know where I live. Oh, okay. Well, that's great. She loves going to school. Yeah. So she'll be moving soon. So I wish you well, Mr. Spiller, and do well in this program, okay? All right. You want those papers back?
Yes.
Okay, great. Thank you. We're adjourned.
I'll meet you downstairs. Thank you. Oh, she has, let's talk about it. I don't know which one you're looking for.
Whatever happens to the diversion,
No, sorry. It's the one that filled out with the various officers, arrest them at such and such date, or just instructed such and such date.
I don't have
Okay. One of the blanks is the property.
Oh, that big, yes, I have it here.
And I didn't write the date, because I didn't know what they were doing actually.
Monday night, I apologize.
It'd be nice to have
No, you're good. I call it release form. Yes. But you call it whatever you want to call it. Sorry about that. Perfect, thank you. Sorry about that. Have a great Monday.
Thank you too.
Thanks, Your Honor. See ya.
Oh, that was, something. You've been coming to my house for months. Picking up my niece. She's disabled, so she gets a little fan. She's in a wheelchair. And so he's been coming to my house. I never saw him. He never saw him. He never got me. Okay. I need to look more. I need to pay more attention. So obviously he's seen me, but I didn't see him. Because usually it's been dark. You know, it's dark outside. Yeah, she's moving. Okay.
It's probably too late to recuse yourself.
Yeah. And the good thing is, I didn't know.
Yeah.
I didn't even. Okay.
Did you see the smile?
Huh?
Did you see the smile?
He said, I work with your niece. Who? He said, Ariana didn't do me. So I'm like, Ariana don't work. She's 12. I was like, what do you do? It's like, what in the world? You kid.
I figured it out. I signed my name on the correct form.
All right. Mr. Medeiros, what are we going to do here today? This is the matter of State of Ohio versus Anthony Medeiros, case number B2201100. Mr. Medeiros is present in the courtroom with his attorney, Ms. Angela Glaser, and Mr. John Rendering is present on behalf of the State of Ohio. This matter is on today, motions hearing. And Ms. Glaser, I want to just review the motions that I have outstanding. And it looks like a motion to unseal the search warrant, a motion to suppress, and then I have several pro se motions filed by your client, which you may or may not have known about. So I'm going to start with the pro se motions first because my inclination is to deny them as moot. First of all, Mr. Medeiros, when you have a lawyer, whether you think your lawyer is doing a great job or not a great job, the court will not entertain motions from you. Do you understand? Because you work, you're being represented by counsel. Do you understand? You may not have known that. Do you understand?
Yes, I understand.
Okay. So you have a motion to suppress evidence, which Ms. Glaser, are you standing on his pro se motion to suppress?
No, Your Honor, so I have filed a motion to unseal / motion to suppress, but I didn't have sufficient evidence at the time to set forward the nature of the motion to suppress. At the last setting, the state of Ohio provided me an unredacted copy of the search warrant for counsel only.
Okay,
So I'm willing at this time to withdraw that portion of that motion that I filed.
I see. All right.
I did plan to supplement the motion to suppress I had previously filed, And it's my understanding that the court cannot entertain motions filed by Mr. Maderas while I'm representing him, so I would prefer that the court not proceed on his motion that he filed.
Yeah, what I'm gonna do is, and I had planned on doing this, just denying his motion to suppress as moot. And then he has a motion demand for dismissal. 7 elements of jurisdiction. I don't even know what that is, but I'm gonna deny it at this time. And, demand for discovery, which that's always legitimate. And I think there was already a, demand for discovery. I don't know if Mr. Maderas was asking for something additional that his lawyers didn't get, but, all the pro se motions will be denied as moot because council is addressing all of them. Motion for bill of particulars, denied as moot. That's the pro se one. And then there's a defendant's motion for Brady material, which is Mr. Maderas's pro se motion. But I want to make sure that there hasn't been a council one that was filed. Otherwise, I will let that one stand. Because Brady is always a very important issue. So I don't want to really deny it. Well, okay, I think it's been addressed already. But under the Constitution, his constitutional right, he is entitled to any Brady material. So while I'm denying the pro se motion, the court does acknowledge that Mr. Maderas is entitled to Brady material, and he should have that. All right, so your motion, counsel, is motion to unseal search warrant and motion to suppress. So the motion to unseal the search warrant is the portion that you wanted to withdraw?
Correct.
Okay. Withdrawn by council today, 3/24/25. And then the motion to suppress stands, and you're gonna supplement.
Correct.
Okay. Now, we have some dates around this case already. And I know this has been pending for quite some time. The court was ready to try the case some time ago. And Mr. Maderas absconded and was AWOL for quite some time from the court. Then we had a date set, looks like this month, jury trial, but the court was already in progress in another jury trial, and so we rescheduled it. Or did we reschedule? No, we didn't reschedule. We need to reschedule it. Okay. Counsel was in a trial too at that time, so it couldn't be done. So now we need to get some dates. All right, how soon are you looking to, will you be able to try this? I know you just got out of a couple of weeks jury trial, and you still need to, you just got the unredacted portions of the search warrant, and we need to do a motion to suppress as well. So when do you, let's put some parameters around this case so we can finally get it on the trial docket. What do you think, Ms. Glazer? And State, I'm asking you as well.
So, Judge, it's my intention to supplement the motion to suppress and just either today or tomorrow.
Okay,
I've started over the weekend, so I'm just wrapping it up now. I would just need a couple of weeks to do the motion. So I'm hoping to resolve this case sometime in April. I have some time additionally at the end of April where I can try it.
okay, State?
I'll be looking forward to seeing the supplemented motion to suppress, and then it'll impact my estimation of how long it should take, but I don't, from my review of the case, anticipate that be a fruitful motion to suppress, but obviously I'm biased. So Your Honor, whatever the timeframe you have, I'm pretty sure, if I'm remembering correct, yes, I was checking through my text messages. The officer's not available starting at the end of June, so we have a preference to get it done before then.
He's not, the end of June?
Yeah, he says he's got a baby on the way.
Okay. So defendant will supplement, motion suppress, and if you can have that supplemented by Friday, the 28th,
That works for my calendar.
this Friday, the 28th, State will have, until April 28th to respond. Evidentiary hearing will be on can you do April 30th?
I am available April 30th.
That worked for me, Your Honor.
All right, so we'll do the suppression hearing April 30th at 10 a.m. And then May 29th would be the final pretrial conference at 9:30. And the jury trial will be well, I have 2 criminal trials and a civil trial. No, one criminal trial. That's not. Yeah, okay. It might work the 9th. Let me look at that civil trial on the 9th first. Miss Maines, can you look at that civil trial on June 9th and see?
Judge, I'm not actually available on May 29th.
You're not?
No, and because it's a final pretrial, I prefer to be here rather than have my associate cover, and I could,
Okay,
in the worst case scenario, have Ms. Hayes cover that day.
we can do June 5th.
Is May 22nd available the week before?
No, I'm out. My niece is graduating and I'm taking that whole day off. She's graduating high school and getting out of my house. Going to college.
June 5th would work then.
June 5th?
Yes.
All right, June 5th. All right, final pretrial conference, June 5th. I just, I have family and all of that coming in from out of town for her graduation. I don't want to do anything that day, so I just take off.
Yeah, that makes sense, I understand.
So June 5th at 9:30 will be the final pretrial conference.
As far as I know, the trial is close together, but there is a motion to intervene coming from another party, so that could change the trial.
That could change it. All right. Well, let's set it for June 9th. 10 o'clock. If you can't do the 9th, I have the 16th. But the only problem with June 16th is we have Juneteenth in that week. And I will be letting the jury off because the courthouse will be closed.
Judge, I prefer June 9th.
All right. June 9th at 10 a.m. All right, so let me just recap. We have our defense is gonna supplement your motion by the end of this week on Friday the 28th. The state's response is due April 28th. The evidentiary hearing will be on April 30th. The final pretrial will be June 5th, and the jury trial will be on June 9th. I am gonna protect that date. It is gonna be on June 9th, okay? This case is way, way, way old, and I'm not gonna let anything get in the way of June 9th jury trial, 10 o'clock, all right? All right, anything else, counsel?
No, Your Honor, thank you.
Time waived?
Time is waived.
All right, thank you very much.
Thank you.
I'm sorry, you talking to me?
Yes.
What'd you say?
I said, can we please not let it go no further than that?
Oh, I'm gonna protect that date. Is it off?
Yes.
Isn't this the same guy that was gone for 2 years?
Yes.
He'll have to go past that.
Mm-hmm. Mm-hmm.